Today we're going to talk about silencers or suppressors and how there is a major series of lawsuits out there in the state of Illinois dealing with whether or not suppressors are arms and thus protected by the Second Amendment. Stay tuned. We're going to get super geeky on this one when we get back. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. If you haven't picked up a copy, check it out. A lot of critical information there for American gun owners, because we always want to learn about the mistakes of others, so we don't make those here. We certainly don't want to be a disarmed citizenship here or citizenry here. That is a fact, and I discuss that in great detail in the book, Disarmed. All right, folks, so suppressors. Major lawsuit. In fact, there's a couple lawsuits out there in the United States District Court for the Southern District of Illinois. I want to talk about suppressors / silencers a little bit because we haven't done it yet. We've talked a lot about magazines, and I want to discuss suppressors. Okay, first of all, the name of the case that's pending out there that I'm going to bring to your attention, I'm going to put some legal briefs down below so you can check it out, is Larry Morris versus Kwame Raoul, and also Carlin Anderson versus Raoul as well. These are both cases that are challenging the state of Illinois' suppressor statute. Specifically, let me tell you what the state of Illinois talks about when they discuss suppressors. This is what they said in their legal documents filed, about a month ago. This is the state of Illinois' attorneys. Illinois law prohibits the possession of silencers defined as, quote, any device or attachment of any kind designed, used, or intended for use in silencing the report of a firearm. Then they cite to the Illinois state statute. It goes on to say in their legal papers, silencers are also regulated under federal law. Among other things, the National Firearms Act requires anyone who transfers a silencer to pay a $200 tax complete with an application that includes the transferee's fingerprints and photograph and register the silencer in the transferee's name with the federal government. It is a federal crime to possess any silencer that has been transferred in violation of these provisions or is not properly registered, period, close quote. That is what the state of Illinois' attorneys have said about their laws involving suppressors. Let's quickly summarize the state of Illinois' position as to why they think they can ban suppressors. In a nutshell, they claim that suppressors are not arms within the text of the Second Amendment. Specifically, the text of the Second Amendment says, the right of the people to keep and bear arms shall not be infringed. The question is, what's an arm? Well, of course, we know what an arm is, but we're going to talk about what Illinois thinks an arm is here. Specifically, does Illinois think suppressors are arms? And they say, no, it does not. Here is what they argue in their motion for judgment on the pleadings filed again about a month ago. The Second Amendment plaintiffs, quote, raise a Second Amendment challenge to an Illinois law prohibiting the possession of silencers, which are attached to firearms to reduce the noise of gunfire. But the Second Amendment protects only, quote, the right of the people to keep and bear arms, arms highlighted. Silencers are not weapons. They are not useful for self-defense. Really? And they are not necessary for the effective use of a firearm. So they are not arms within the meaning of the constitutional text of the Second Amendment, and thus the Second Amendment plaintiffs cannot prevail on their Second Amendment claim. Well, to begin with, let's just use a little bit of common sense, which I know is not that common in today's world. If suppressors, silencers, are not arms, are not really viewed as weapons, then why is it the state of Illinois bans them under a statute that is labeled deadly weapons? Why is Chapter 24 of the Illinois Code labeled deadly weapons, and under that includes, among other things, suppressors? Do you know what else is in that definition? Not certain types of knives, bludgeons, blackjacks, throwing stars, and other weapons. Well, seems to me the state of Illinois thinks that suppressors are indeed deadly weapons. That's why they put it in the definition of deadly weapons. Hello, how hard is this? It's not that hard. Beyond that, let's talk about the two most important, prominent federal gun laws in America. The National Firearms Act of 1934 and the Gun Control Act of 1968. Guess what? Those definitions talk about silencers, which are considered firearms in the context of those laws. So if you think about it, Illinois, in their statute in covering deadly weapons, puts suppressors and silencers in there. So does the federal government in both of their major statutes, the Gun Control Act and the National Firearms Act. So it seems to me the people passing the laws trying to regulate or ban firearms and weapons consider suppressors to be such. Game over on its face, as I see it. But let's continue on and do the analysis. As we know from the Heller case, anything that's in common use as an arm is protected. The Heller case deals with gun bans, arms bans. And if it's in common use, it's protected. But we're not going to talk about in common use right now. We're just going to talk about whether or not suppressors and silencers are arms. Suppressors and silencers are the same for our purposes, but I may use those words interchangeably here in this video. The question really is are these suppressors useful or helpful in facilitating the use of a firearm for lawful purposes? And the answer is undeniably yes, right? For example, let's talk about some other things that are essential and also helpful to the use of firearms that are not in and of themselves weapons. Because really, Illinois is saying that, hey, a suppressor by itself is not an arm. Therefore, it's not an arm. Well, that's absurd, because a magazine by itself is not an arm, according to their definition, which is very convenient for the anti-gun movement, but it helps facilitate and actually helps use, right? They aren't protected by the Second Amendment. So too, by analogy involving the First Amendment for just 1 second, ink is not speech. Ink is not press. But ink is protected, according to the U.S. Supreme Court under the First Amendment, in the Minneapolis Star case from 1983, because it helps advance and helps people effectuate their right to free speech and their right to the free press. So too is the internet, so too are computers, so too is a television, so too is a phone, so too is money. None of these things in and of themselves are speech or are press or media. But they all help facilitate or are useful in the effectuation of our First Amendment rights to free speech and the First Amendment right to free press. Likewise, items that help facilitate or are useful for our Second Amendment right to keep and bear arms, i.e. the use of guns, are also protected. Let's just think about a few of these things. Could Illinois ban, let's say, red dot sights for firearms? Could they make laser points illegal? No, I don't think so. Because you're making firearms capable of aiming with the use of a laser. You can't do that because, again, a laser pointer on a firearm helps you aim that firearm. So too, what about a barrel? Well, a barrel, again, is helpful for the use of a firearm. In fact, it's actually essential. So a barrel in and of itself is not an arm. It's just a pipe. But of course, it's an essential part. What about a rifled barrel? Right? You have a smoothbore barrel for shotguns or muskets back in the day. But then you have rifled barrels. Could the government ban rifled barrels on the grounds that rifling inside the barrel, also known as the bore, a rifled bore is not essential, but it certainly is helpful and useful for making firearms effective and shoot accurately. Could they ban rifling? No, I don't think so. Again, keep in mind that Illinois has got a little bit of a dilemma here, because in their case involving magazines, they're trying to say that magazines are really not arms. And then now we're trying to argue suppressors are not arms. But again, some of their positions to me seem a little in tension. Nevertheless, the reality is that magazines are protected arms because they're useful for self-defense and they're useful for the lawful use of firearms. So too are suppressors. Now, actually, the state of Illinois argues suppressors are not helpful in any respect. But that's not true. And of course, receivers and frames, a receiver for a long gun and a frame for a handgun, they're not arms in and of themselves. I know that's how they're defined under federal law, but the reality is they're not arms, they're not firearms, but they're necessary and they're helpful for developing and using firearms. So they're protected arms under the Second Amendment. Now, what's interesting is the arguments by the state of Illinois also argue that silencers are not necessary for the effective use of firearms. But again, I don't think that's the test, because silencers may facilitate arm action. And if you recall, in the Nysurpa versus Bruin case, the Supreme Court said that items that help facilitate armed self-defense are protected. Obviously, suppressors help facilitate armed self-defense. This is especially true in close quarters. So, for example, I don't need to tell those of you out there, silencers or suppressors are very helpful for protecting our hearing. In fact, the CDC has specifically said that even 22 pistols, when fired, give rise to a noise decibel level that is too high under the CDC safety requirements. I believe the maximum safety threshold for the CDC is 140 decibels. And if you fire a 22 caliber pistol, it is above that. So even the smallest guns among us are too loud without a suppressor or silencer to suppress and quiet them down enough so they don't cause us to lose our hearing, which obviously nobody wants to do. Set aside the fact, by the way, in places like Europe, every country basically uses suppressors and encourages it because you're considered rude if you don't. Of course, suppressors are helpful for self-defense. Why? Well, if you're firing this gun in the home, even if it's a 22 pistol, as I've just illustrated, any firearm you're firing in the home, if you fire that gun off and it's too loud because you don't have a suppressor on it and you don't have hearing protection, guess what? You're probably not going to be able to hear anything else after you fire that first shot, because your hearing is going to be a ringing of your ear, which means you're not going to be able to hear instructions given by a 911 operator. You're not going to be able to hear instructions given by a police officer responding to the scene. You might not hear your family members yelling for help or telling you they're out of harm's way. They've run out in the front porch, whatever it is, they're away. And maybe you can't hear where the bad guy's coming because, again, after you touch off that first round, your ears are going to be ringing from that loud noise, which you would be able to avoid with a suppressor. So obviously they are indeed helpful for self-defense, especially in the home. So it seems to me that suppressors should be protected as arms under the Second Amendment. I think that is clearly the right answer. We'll see what the judge does in the United States District Court for the Southern District of Illinois in these cases. I do also want to mention just a couple other items that are interesting thought experiments. For example, if you go back to the time of the founding, a stick was often used, was used by the Minutemen and other people at the time of the founding. That stick was known as a ramrod. And those ramrods were used, of course, with a patch and the powder to push down the ammunition in the form of a ball down either a rifled bore in the form of a rifle, if it's a rifle you're firing, or down the smooth bore musket. But again, is that ramrod a protected arm? I would say yes, because again, it's helpful to using the firearm, even at the time of the founding. Of course, people use black powder today, but you get the idea that it seems to me ramrod, because again, it's useful and helps facilitate the use of the firearm, indeed is a protected arm. So too, I would argue, is a flashlight if you attach it to an arm, because again, the flashlight helps you in nighttime combat situations, meaning you're in self-defense mode, you're trying to protect your family, you're in a home, everything is dark, you want to be able to see where the bad guy is, you don't want to shoot the wrong person, and a flashlight, again, helps the arm succeed in its mission, which is to protect you and your family against the bad guy. It is helping the arm do its job, and as a consequence, it should be a protected arm under the Second Amendment, no different than a magazine. And of course, the last point to be made is, of course, we know that silencers do not silence the gun entirely. It simply reduces the report, the noise of the firing of the gun, so that you can protect your hearing and don't go deaf in the event that you need to use your firearm for a self-defense situation, or if you just want to use it lawfully at a gun range and beyond. The bottom line, though, is here we are in the Southern District of Illinois. This is a major series of cases out there pending. I'm going to keep you in the loop. I'll put some links to the critical briefing down below. You should check it out. I know a lot of you are interested in suppressors. A lot of you have these NFA items. And as to whether or not they should even be within the NFA and taxed under the NFA, I'm skeptical that any of that is legal. Nevertheless, one step at a time. And I think the first critical step is for courts to start to find these suppressors are arms under the definition of the Second Amendment, i.e. within the scope of the right of the people to keep and bear arms. Once they fall within that notion of arms, I think that that is a huge first step in our effort to try to get suppressors out of the NFA because they never should have been in there in the first place. Nevertheless, this is the world in which we now live in. It's not perfect, but there is no such thing as the perfect world, so we all have to keep battling on to protect our rights, just like prior generations and probably future generations will have to do the same. Okay, folks, hope you learned a little bit something here today about suppressors, these pending lawsuits, how to think about whether or not they're arms. Hope it was helpful. If you haven't subscribed to the 4 Boxes Diner, please do so. Check us out on Twitter at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.